I have presided over cases involving fraud, false injuries, fabricated evidence, and witnesses who swore under oath to things that were plainly impossible. But there was one morning when a heavyset woman named Karen Mitchell sat in my courtroom, pointed proudly at her 18-month-old baby, and claimed the child could hold full conversations. Not baby sounds, not simple words, conversations. According to Karen, her toddler could describe events, identify legal wrongdoing, and even explain exactly why she deserved thousands of dollars in damages. Believe me, the moment I heard that claim, I knew I was about to witness something extraordinary. What I did not know was that Karen's own argument would collapse so spectacularly that the entire courtroom would fall silent. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a man named Brandon Ellis, 38 years old, owner of a family-operated daycare center, professional calm, the type of person who carefully chose every word before speaking. Across from him sat Karen Mitchell, a heavyset woman in her early 40s, loud, confident, and carrying her toddler son on her lap as though the child was her star witness. Years on the bench teach you something important. People who possess strong evidence usually present documents. People who lack strong evidence often present emotions. Karen seemed determined to present emotions. The lawsuit involved a daycare dispute. According to Karen, Brandon's daycare had emotionally traumatized her son during a brief enrollment period. She claimed the staff mistreated him, ignored him, and caused severe emotional distress. Interesting, very interesting, because daycare records appeared to tell a completely different story. I asked Brandon to explain. He calmly presented attendance logs, staff reports, daily activity summaries. Everything appeared organized, very organized. Karen interrupted before he finished his second sentence. He's lying. Interesting, very interesting. Not. Those records are incorrect. Not. Those dates are wrong. Just, he's lying. Years on the teach you that broad accusations are usually much weaker than specific contradictions. Karen's accusation was broad, very broad. I asked her what evidence she possessed. She immediately pointed at her son. The courtroom became quiet. Evidence? Yes, my baby told me everything. Interesting, very interesting. The spectators exchanged looks. Brandon looked confused, honestly. So did several people in the gallery. I leaned slightly forward. Your son told you everything? Yes, he explained what happened. Yes, interesting, very interesting, because the child appeared extremely young, far too young for the kind of detailed conversations Karen was describing. That observation immediately caught my attention. I asked her how old the child was. 18 months. The courtroom became silent, domiciled silence. Years on the bench teach you to remain composed. But even I found that answer remarkable. An 18-month-old, interesting, very interesting. I asked her to explain. Karen immediately launched into a lengthy story. According to her, the child described specific daycare incidents, specific staff members, specific conversations, specific events. The more she talked, the stranger the story became. Years on the bench teach you something else. When testimony becomes too detailed, credibility often begins decreasing instead of increasing. Karen's testimony was becoming very detailed, very quickly. Then I asked a simple question. What exactly did your son say? Karen smiled, actually smiled. That caught my attention immediately because she seemed proud, very proud, she answered confidently. He told me the teacher was mean. Interesting, very interesting. I looked toward the toddler. The child was happily chewing on a toy, completely uninterested in the lawsuit. That observation mattered a lot. Then Karen continued. He also told me they ignored him during snack time. Interesting, very interesting. And how exactly did he communicate that? Karen immediately answered. He talks. The room became quiet again, not because anyone was convinced, because everyone was trying to understand where this was going. Then Brandon submitted something unexpected. A developmental assessment completed only weeks earlier. Interesting, very interesting. I reviewed it carefully. Then again, then a third time, because one section immediately caught my attention. According to the assessment, Karen's son knew approximately 12 words. 12. Interesting, very interesting. The report specifically noted that the child was still developing basic speech patterns. The courtroom became silent. I looked toward Karen. She immediately shifted in her chair. That reaction mattered a lot. Years on the bench teach you that people often react before difficult questions arrive. Karen already knew what I was about to ask. I held up the assessment. Did you provide information for this report? A pause. Then, yes. Interesting, very interesting, because now we had a problem, a very large problem. According to Karen, the child could describe detailed daycare events. According to her own assessment records, he was still learning basic vocabulary. Both stories could not comfortably exist together. The courtroom remained silent. Then Karen smiled again. Actually smiled. That immediately caught my attention, because people usually don't smile when contradictions appear unless they believe they possess something stronger. And judging by her confidence, Karen believed she had a secret weapon. What she revealed next would shock the entire courtroom. And honestly, at first, even I wasn't sure whether she was serious. The moment Karen Mitchell smiled, I knew she believed she had found a way around the contradiction. Years on the bench teach you that people rarely remain confident when evidence begins hurting them, unless they think they possess a stronger argument. Karen clearly believed she did. The courtroom remained silent. Brandon Ellis sat calmly. The spectators watched carefully. The toddler remained focused on his toy, completely unaware that he had become the center of a lawsuit. Interesting, very interesting. I looked toward Karen. What exactly are you smiling about? Karen immediately leaned forward. My son is gifted. Interesting, very, very interesting. Not advanced, not intelligent. Gifted. That distinction caught my attention. Because people often use extraordinary explanations when ordinary explanations stop working. I asked her to explain. Karen proudly announced that her son had abilities far beyond his age. According to her, doctors were amazed. Family members were amazed. Neighbors were amazed. Everyone was amazed. Interesting, very interesting. Years on the bench teach you something important. The more people someone claims agree with them, the more carefully you should examine the evidence, because evidence matters, not applause. Then Karen made a statement that immediately changed the atmosphere in the room. She pointed toward her son and confidently said, "He speaks like a 4-year-old." The spectators exchanged looks. Brandon lowered his head, and honestly, several people appeared to be struggling not to laugh. I wasn't, because my job isn't to laugh. My job is to understand. And understanding often requires patience. I asked Karen if she had any recordings, any videos, any documentation showing the child's remarkable communication abilities. Interesting, very interesting. Because if her claim were true, evidence should exist. Karen smiled. Yes. Interesting, interesting, very interesting. That answer caught my attention immediately, because now we were moving from stories to evidence. Or so I thought. Karen handed over a flash drive. The courtroom remained silent. I reviewed the first video, then another, then another. And honestly, the more I watched, the more interesting things became very interesting, because every video followed the same pattern. Karen would ask a question. The child would make a sound. Then Karen would immediately translate. Interesting, very interesting. I watched carefully. Did daycare make you sad? The toddler responded, bah. Karen immediately nodded. See, that's yes. Interesting, very interesting. Then another video. Did the teacher yell at you? The child responded, duh. Karen nodded confidently. That's exactly what he says when he's upset. The spectators exchanged looks because everyone was beginning to notice the same thing. The child wasn't speaking. Karen was interpreting. That distinction mattered a lot. Years on the bench teach you that interpretation can be dangerous, especially when the interpreter benefits from the interpretation. Karen seemed to benefit enormously. Then I reviewed another video. And honestly, this is where things became fascinating, because Karen asked 5 completely different questions. The child gave nearly identical responses. Yet Karen assigned 5 completely different meanings. Interesting, very interesting. The courtroom became quiet. I looked toward Karen. Who taught you what these sounds mean? A pause. Then, I'm his mother. Interesting answer. Very interesting answer. Because mothers know their children exceptionally well. But that doesn't automatically transform babbling into courtroom testimony. That distinction mattered a lot. Then Brandon submitted something unexpected, a report from a licensed child development specialist. Interesting, very interesting. The moment Karen saw it, her confidence weakened. Only slightly, but enough for me to notice. Years on the bench teach you to pay attention to small changes. Small changes often reveal large concerns. I reviewed the report. Then a third time, because the wording immediately caught my attention. The specialist observed the child over multiple sessions. According to the report, the toddler demonstrated normal language development for his age. Interesting, very interesting, normal, not extraordinary, not advanced normal. The report further stated that many of the sounds Karen interpreted as complex communication were developmentally typical vocalizations. The courtroom became silent. I looked toward Karen. She immediately crossed her arms. Interesting, very interesting, because defensive body language often appears when expert opinions become difficult to challenge. Then something happened. The toddler dropped his toy. The toy landed several feet away. The child pointed at it and said one word, ball. The courtroom smiled, a genuinely adorable moment. Interesting, very interesting. Because unlike everything else discussed that day, that word was clear, civil, authentic, and completely age appropriate. The child looked proud. The spectators smiled. Even Brandon smiled. Then Karen quickly interrupted. See? He's advanced. Interesting, very interesting, because she seemed determined to transform every normal behavior into extraordinary evidence. Years on the bench teach you that extraordinary claims require extraordinary proof. Karen had provided very little proof. Then I found something else inside the daycare records, a daily report. One particular report, and honestly, the moment I read it, I knew the case was about to become much more complicated, because according to Karen's own messages to the daycare, only 3 months earlier, she had written something that completely contradicted everything she was now claiming in court. And judging by her reaction, she knew exactly which message I had found. The moment I found Karen Mitchell's message inside the daycare records, I stopped reading everything else. Not because the other documents weren't important, because this one was very important. Years on the bench teach you that people often tell the truth before they realize they may later need a different story. And when those earlier statements appear in court, they can become very difficult to explain away. The courtroom remained silent. Brandon Ellis sat calmly. The spectators watched carefully. Karen stared at the table, and honestly, the moment she saw me reviewing that message, her confidence visibly weakened. That observation caught my attention immediately, because people rarely fear evidence that helps them. I read the message once, then twice, then a third time, because the wording mattered. A lot. The message had been sent by Karen directly to the daycare director, only 3 months before the lawsuit. Interesting. Very interesting. I looked toward Karen. Did you send this? A pause. Then, yes. Interesting. Very interesting, because now we had confirmation, not speculation, not assumptions. Confirmation. I began reading. I'm worried because Jacob still isn't talking much. The courtroom became silent. Domvolate silence. I continued. He only says a few words. Interesting. Very interesting. Then came the next sentence. I hope daycare interaction helps his speech development. The room froze, because suddenly we had a problem, a very large problem. 3 months earlier, Karen described her son as having limited speech. Now she claimed the same child was holding detailed conversations about daycare misconduct. Interesting, very interesting. I looked toward her. Can you explain the difference? The spectators leaned forward. Brandon remained silent. Karen shifted in her chair. Years on the bench teach you that difficult questions often produce long pauses. This pause was very long. Finally, she answered. He developed quickly. Interesting answer. Very interesting. Possible. Certainly, children can develop rapidly. The problem was that the timeline still didn't make sense. Not according to the records, not according to the specialist, not according to the videos. That distinction mattered a lot. Then I reviewed another daycare communication. Interesting, very interesting. The moment I saw the date, I knew it was important, because this message was sent only 2 weeks before Karen withdrew her son from the daycare. I read it carefully, then again, then a third time, because honestly, I could hardly believe what I was reading. The message stated, "Thank you for helping Jacob become more comfortable around other children." The courtroom became silent. I continued. His speech is improving. Interesting, very interesting, because that message sounded remarkably positive, not like the description Karen was presenting now, not even close. I looked toward her. Did you write this? A pause, then, yes. Interesting, very interesting, because now another contradiction appeared. Karen's current testimony described a traumatic environment. Her earlier messages described progress. That difference mattered a lot. Then I reviewed attendance notes from the daycare staff, daily observations, Dacdembity participation, snack time reports, play sessions. Everything appeared organized, very organized. Then one entry immediately caught my attention. Interesting. Very interesting, the note described Jacob participating in a music activity. According to staff observations, he spent most of the session happily dancing. The spectators smiled. Then I found another entry, story time, egg positive. Another, outdoor play, egg positive. Interesting, very interesting. The pattern was remarkably consistent. That observation mattered because genuine trauma usually leaves traces, behavioral changes, reports, incidents, something. The records contained very little of that. Then Karen suddenly interrupted, for the first time in quite a while. He acted differently at home. Interesting, very interesting. Because now we were entering territory difficult to verify, not impossible. But difficult. I asked her how. Karen immediately answered. He told me what happened. The room became quiet again. Because we had arrived back at the central claim, the talking baby, the child witness, the foundation of her entire case, years on the bench teach you something important. When a case repeatedly circles back to one fragile claim, that claim deserves careful examination, very careful examination, then I notice something else. A notebook, interesting, very interesting. Karen had brought a notebook. I had seen it earlier, but now it suddenly interested me. A lot. I asked about it. Karen immediately looked uncomfortable. That reaction mattered a lot. Years on the bench teach you that people often reveal the importance of evidence before anyone else understands it. Karen looked genuinely nervous. I asked what the notebook contained. She hesitated, then answered, "My son's statements." Interesting, very interesting. The courtroom became silent because suddenly the alleged conversations existed somewhere other than Karen's memory, or so it seemed. I requested the notebook. Karen hesitated again, longer this time. Interesting, very interesting. Eventually she handed it over. I opened the first page, then the second, then the third. And honestly, the more I read, the stranger the situation became, because according to the notebook, Jacob wasn't merely speaking. He appeared to be giving detailed narratives. Multi-sentence narratives, complex narratives, narratives that sounded remarkably similar to adult language. The room became silent, consult silence. I looked toward Karen, then back at the notebook. Because one particular entry immediately caught my attention. The wording was extraordinary, far too extraordinary. In fact, the sentence supposedly spoken by an 18-month-old child contained vocabulary many adults rarely use, and that observation was about to change everything. The moment I noticed the vocabulary inside Karen Mitchell's notebook, I knew we had reached a critical point. Not because toddlers cannot surprise us. Children do remarkable things all the time. But years on the bench teach you that extraordinary claims require extraordinary evidence. And what I was reading felt less like a toddler's words and more like an adult's argument. The courtroom remained silent. Brandon Ellis sat quietly. The spectators watched carefully. Karen looked increasingly uncomfortable. And honestly, that reaction alone interested me very much, because people rarely become nervous when evidence supports their position. I reviewed the notebook again, then another page, then another. The entries were remarkably detailed, interesting, very interesting. According to Karen's notes, her 18-month-old son had allegedly said things like, "The daycare environment makes me feel emotionally neglected." The room became silent. Absolute silence. I read it again because even after years on the bench, I wanted to make sure I wasn't imagining it. Interesting. Very interesting. An emotionally neglected 18-month-old using the phrase emotionally neglected. That observation mattered a lot. I looked toward Karen. Did your son actually use those words? A pause. Then, that's what he meant. Interesting answer, very interesting answer, because now something important had changed. Earlier, she claimed the notebook contained her son's statements. Now, she was admitting interpretation. That distinction mattered enormously. Years on the bench teach you that interpretation often becomes more dramatic than reality. And Karen's interpretations were becoming very dramatic. Then I reviewed another entry. Interesting, very interesting. This one allegedly described snack time, according to the notebook, Jacob stated. The caregiver demonstrated favoritism toward other children. The spectators exchanged looks. Several appeared genuinely stunned. Honestly, I couldn't blame them, because most adults don't casually use the phrase demonstrated favoritism, yet somehow an 18-month-old allegedly did. Interesting. Very interesting. I looked toward Karen again. How many words does your son currently know? A pause. Then another pause. Then I don't know exactly. Interesting. Very interesting. Because earlier she seemed remarkably certain about his communication abilities. Now, certainty was disappearing. That observation mattered a lot. Then Brandon submitted something unexpected, a video. Interesting, very interesting. The moment Karen saw it, her expression changed immediately. Years on the bench teach you to pay attention to those moments. People often reveal the importance of evidence before anyone else understands it. Karen looked frightened, actually frightened. I reviewed the video. The recording came from Karen's own social media account. Interesting, very interesting. The date immediately caught my attention. Only 6 weeks before the lawsuit. The video showed Karen sitting in her living room with Jacob. Nothing unusual at first. Then Karen began speaking. "Can you tell everyone what happened at Daycare?" Interesting, very interesting. The toddler responded. But Karen immediately nodded. Exactly. The spectators exchanged looks. I continued watching. "What did the teacher do?" The child responded. "Duh." Karen nodded again. "That's right. Interesting. Very interesting." The pattern was obvious. Karen asked, the child made a sound. Karen supplied the meaning every single time. Years on the bench teach you that leading questions can produce almost any answer you want. This video demonstrated that perfectly. Then I found another clip, and honestly, this one changed everything. The second video showed the same interaction, the same child, the same questions. But this time, Karen forgot something important, something very important. The recording continued after she thought it ended. Interesting, very interesting. I leaned forward slightly. The courtroom became silent, Dodfalutzel silence. Because what happened next was extraordinary. The child made random sounds, normal toddler sounds, completely ordinary. Then Karen turned towards someone off camera and said, "I'll write down something stronger later." The room froze. Nobody moved. Nobody spoke. Even Karen looked stunned hearing her own voice. Interesting, very interesting. Because suddenly the notebook looked very different. The alleged statements looked very different. Everything looked different. Then I reviewed the rest of the clip. And honestly, the deeper I looked, the worse things became. Karen continued discussing potential wording, potential descriptions, potential accusations, everything. Interesting, very interesting. The spectators stared at the screen. Brandon stared at the screen, and Karen stared at the table, because for the first time all day, the notebook was no longer supporting her case. It was destroying it. Then I found something else inside the video archive, a clip uploaded only days before the hearing, a clip Karen clearly never expected to become courtroom evidence. The moment I opened it, I knew we were approaching the viral courtroom moment people would discuss for years, because the video showed Karen speaking directly to her followers. And what she said next would completely expose the truth behind the entire lawsuit. The moment I opened that final video, the entire courtroom became silent, not ordinary silence. The kind of silence that arrives when everyone senses something important is about to happen. Years on the bench teach you that people often reveal their true intentions when they believe they are speaking privately. Karen clearly believed this video would never appear in court. That assumption was about to become very expensive. The courtroom remained still. Brandon Ellis sat quietly. The spectators leaned forward. Karen stared at the table. And I began reviewing the recording. Interesting, very interesting. The video had been posted to a private subscriber group, not public, not widely available, only visible to a select audience. That detail mattered a lot because people often speak differently when they believe outsiders are not listening. I pressed play. Karen appeared on screen, relaxed, confident, smiling. Very different from the woman now sitting in my courtroom. Interesting, very interesting. Then she began speaking. At first, the conversation appeared harmless. general updates, family discussions, normal content. Then the subject changed. The daycare lawsuit, the room became silent, double silence, because suddenly Karen was discussing the very case sitting before me. I listened carefully. Then I heard the sentence that immediately caught my attention. Interesting, very interesting. Karen laughed and said, "People believe anything when kids are involved." The room froze. Nobody moved. Nobody spoke. Even Karen closed her eyes because she knew, she absolutely knew. That sentence was devastating. Then it got worse, much worse. I continued watching. Karen smiled and said, "That's why Jacob is perfect." The spectators exchanged stunned looks. Brandon stared at the screen. And honestly, even after years on the bench, moments like that still surprise me. Because sometimes people document their own motives. Karen appeared to be doing exactly that. Then came the next sentence, the sentence that changed everything. I read it once, then replayed it again, because I wanted to be absolutely certain. Karen looked directly into the camera and said, "He doesn't actually tell me anything. I just know what sounds convincing." The courtroom exploded. Gasps, whispers, shock, actual shock. The court officer immediately called for order. Again and again and again, because nobody could believe what they had just heard. Interesting, very interesting, the alleged child witness, the notebook, the daycare accusations, everything. Suddenly it all made sense. Not because Jacob had communicated detailed complaints, because Karen had created them. The room slowly quieted. I continued reviewing the video. And honestly, the deeper I went, the worse it became. Karen discussed audience reactions, sympathy, engagement, public support, everything. Interesting, very interesting. Then she laughed again and said something I will never forget. Years on the bench teach you that certain sentences stay with you forever. This was one of them. Karen said, "Who argues with a baby?" The room froze again. Because suddenly the entire strategy became visible. Not evidence, emotion, not facts, sympathy, not testimony, manipulation. That distinction mattered a lot. Then I found another section. And honestly, this is where the hearing became unforgettable. Karen discussed potential settlement outcomes. Interesting, very interesting. She wasn't discussing daycare improvements or child safety or accountability. She was discussing money, specifically money. The room remained silent. I reviewed the transcript carefully, then another time, then a third time. Because the wording was extraordinary, Karen stated, "If they get scared enough, they'll settle." The spectators exchanged looks. Brandon slowly lowered his head. And honestly, I think that was the moment everyone understood what had happened. Not a misunderstanding, was not a parenting concern, a strategy, a calculated strategy. Then I reached the final portion of the video. And this is where the viral courtroom moment occurred, because Karen's own followers began asking questions. Interesting, very interesting. One follower asked, "Can Jacob really say all those things?" The room became silent, dominant silence. Karen laughed, then answered, and honestly. The moment she spoke, the entire case ended because she said, "Of course not, he's a baby." The room exploded. Actual shock. Several spectators gasped out loud. Others covered their mouths. Even Karen looked horrified hearing her own words, because there it was, not interpretation. Not speculation, not accusation, a confession, a direct confession from Karen herself. The notebook, the allegations, the statements, everything collapsed in a matter of seconds. Then I noticed something else, a timestamp attached to the recording. Interesting, very interesting. The video had been recorded only 8 days before the hearing. 8 days. Meaning Karen entered my courtroom fully aware that the story was false. That observation mattered enormously. Then Brandon quietly handed me one final document. A document Karen clearly did not know existed. I reviewed the first page, then the second, then the third. And suddenly I realized that losing the lawsuit was about to become the smallest of Karen's problems, because according to that document, someone else had already begun investigating her conduct long before this hearing ever started. The moment I opened Brandon Ellis's final document, I knew the hearing had reached its conclusion. Not because every question had been answered, because the most important question already had. Years on the bench teach you that credibility is the foundation of every case. And Karen Mitchell's credibility had completely collapsed. The courtroom remained silent. Brandon sat quietly. The spectators watched carefully. Karen stared at the table. And I began reviewing the final records. Interesting, very interesting. The document came from a private investigator retained by Brandon's insurance carrier after the lawsuit was filed, not before. After that distinction mattered a lot, because the investigator wasn't searching for a story, he was verifying one. I reviewed the report carefully, then again, then a third time. Because details matter, especially when someone's entire lawsuit depends upon them. The report summarized social media activity, public statements, video recordings, communications, everything. And one conclusion appeared repeatedly. The allegations evolved over time. Interesting, very interesting, not stronger evidence, stronger accusations. That distinction mattered enormously. The earliest complaints described minor concerns. Then came emotional distress, then neglect, then mistreatment, then detailed conversations allegedly spoken by a toddler. The story became more dramatic as time passed. Years on the bench teach you that genuine accounts often become clearer over time. Fabricated accounts often become larger. Karen's story had become much larger. Then I reviewed the final appendix. And honestly, this was the moment I stopped seeing a daycare dispute, because according to the investigator, Karen had used similar tactics before. Interesting, very interesting, not identical cases, similar patterns, public accusations, social media pressure, settlement discussions, escalating claims. The courtroom became silent because now another pattern had emerged. Parse matter. A lot. I looked toward Karen. She no longer argued, no longer interrupted, no longer corrected anyone. Interesting how quickly certainty disappears when evidence accumulates. Then I returned to the video confession. The statement still echoed in my mind. Of course not. He's a baby. Years on the bench teach you that some admissions are impossible to recover from. That was one of them, not because it was dramatic, because it was simple. Simple statements are often the most powerful. Then I turned toward Brandon Ellis, the daycare owner, the man who spent months defending himself against accusations that could destroy a business built over many years. The man whose employees had been questioned. Woe's reputation had been damaged. Woe's daycare had been scrutinized, all because of claims that the evidence failed to support. That observation mattered a lot. I reviewed the daycare records one final time, attendance reports, development notes, dot-pointed communications. Everything pointed in the same direction, not trauma, not abuse, not neglect. Normal daycare experiences. The evidence was overwhelming. The contradictions were overwhelming. And Karen's own words had become the strongest evidence against her. I entered judgment in favor of Brandon Ellis, still direct, scored entirely by facts. The claims failed, the evidence failed to support them, and the court could not ignore that reality. The room remained silent. Karen lowered her head. No objections, no speeches, no explanations, nothing, because there was nothing left to explain. Then I looked around the courtroom. at the spectators, at the documents, at the people who had spent hours watching the truth emerge piece by piece. And honestly, I found myself reflecting on something much larger than the lawsuit. Years on the bench teach you that children deserve protection. Always Pot Kents deserve to advocate for them, always. But when someone places words into a child's mouth that the child never spoke, something important is lost. Trust, and trust is difficult to rebuild. That observation stayed with me a lot. Then I remembered the moment Karen first pointed toward her son and proudly announced, "My baby told me everything." Interesting, very interesting, because by the end of the hearing, everyone understood something important. The baby hadn't told anyone everything. The baby had told almost nothing. Karen supplied the rest. And eventually, her own recordings exposed it. Years later, I still remember the silence that filled the courtroom after her private video played. Not because people were shocked that a toddler couldn't provide complex legal testimony. Most already suspected that. They were shocked because Karen admitted it herself. The notebook, the accusations, the detailed statements, everything collapsed in seconds. And honestly, the most innocent person in that entire courtroom was the child at the center of it all, a toddler who spent most of the hearing playing with a toy, completely unaware that adults had built an entire lawsuit around him. That thought stayed with me long after the case ended, because some cases are not remembered for the verdict. They are remembered for the lesson. Karen believed people would accept any claim if it came from a baby. She believed sympathy would outweigh evidence. She believed emotion would outweigh facts. Instead, facts waited patiently. The videos appeared, the records appeared, the contradictions appeared, and eventually the truth became impossible to hide. Fat Karen claimed her baby could talk. But the moment her own recording revealed what she really believed, the entire courtroom was left speechless. And once that happened, the case was over.